We're here with special guest Dominic Lascara of Lascara Law. He's located here in Chesapeake, Virginia. Mr. Lascara has been practicing law for nearly 30 years, primarily in the areas of residential and commercial real estate and financing, business and corporate law, contract law, wills, trusts, and the probate of estates and elder law. And he's here to talk to us today about wills and trusts.
Donnie, it's always a pleasure to be in your company. Give us a quick background. You know, I know it's very dry what Joyce just mentioned about your background, but tell us a little more about yourself and your practice.
Okay. Well, Paul, first of all, thank you and Joyce for having me here today. It is appreciated. I started practicing law in 1986. I graduated from the Marshall Witt School of Law at the College of William and Mary. And immediately I went into the real estate practice with the firm that I associated myself with. I've been practicing real estate law for over 35 years now. My practice is generally very transactional, real estate closings, drafting contracts. I also have a business practice, a corporate practice, a transactional wills, trust, and estates practice, and I used to even practice bankruptcy law, which I no longer do.
I know you're well qualified to speak to the issues that we as realtors run into. And one of the elements that we really want to touch upon is what kind of estate planning your firm and you provide to people with regard to the succession of ownership of their property, either, I would assume, commercial and residential. Can you touch on that? So, because we're going to ask you more questions about wills and trusts and living trusts and dead trusts and all kinds of stuff.
Yes. I mean, first of all, anyone that comes to see me with an estate, and that includes real estate, the first and foremost, we just want to make sure that that real estate goes to their intended beneficiary. Secondly, we look to ways that it can get to that beneficiary as easy as possible, as painless as possible, as inexpensive as possible.
Well, I always hear the term probate, and that probate is a term that is somewhat innocuous, but is very encompassing. Can you explicate for us? And Joyce, you want to kick in on probate? I throw the word around like I'm at a cocktail party. Oh, yeah, well, it's in probate. Well, what does that mean? I don't know, but it sounds good. But now we got somebody who can tell us about it.
Can you
Yeah, well, first of all, you have to understand that probate is a process. And it's a process of disposing of someone's assets through a court system. When there's a probate involved, there's a series of events that takes place. First of all, the named executor, if there is a will, or an administrator, if there is no will, and I know you'll want to talk more about that also, gets qualified by the circuit court clerk's office to fulfill the duties that are bestowed upon them in their capacity. Within 30 days, that executor or that fiduciary is required to notify not only the beneficiaries named in the will, but the legal heirs at law of the decedent. Within 4 months, that executor has to file with the court an affidavit that they fulfilled that duty in giving notice to all of the parties. Also, within 4 months, that executor has to file an inventory with the Commissioner of Accounts. The Commissioner of Accounts is a court-appointed official that oversees the executor's duties in administering the estate. Wait, one more thing. And then within 16 months of that qualification, that executor has to file an accounting with the court.
Okay. Now, is that true of a person who has died with a will, or is that true of a person who's died without a will? And in that, what does intestate mean?
All right. Well, that probate process that we were talking about is true for any estate, whether it's a will or lack of will, where there are more than $25,000 of assets that are passing through probate.
So the delimiter for this is $25,000.
Anything under $25,000 is considered a small estate, and the court doesn't supervise it as it would with a larger estate.
So if my grandmother, when she died, and she died without a will, we went through a process because she had some holdings, and they definitely exceeded $25,000, but not by a significant amount of money. So if those had been valued at less than 25, then I could have done with it whatever I wanted to do. Is that right?
You would still had to qualify because there's no way you would have gotten money out of her bank accounts unless you qualified as the administrator of that estate. But essentially, you would just honor your duties without having to be court supervised.
Okay.
And is it typically then so it takes over a year for this entire process?
Many times it can take several years. It depends on the assets involved in the estate. One of the assets could be a promissory note that is owed to the decedent, and that promissory note might not pay out in the first year. So the estate or the disposition of the assets may take longer. Maybe it's a piece of real estate that they can't sell within the 1 year, so the estate would be kept open until the estate is exhausted of its assets.
Okay. So let's take a regular person. I'm a regular person. I have a wife. I have a son. I have children by my first wife. I have grandchildren, but I don't have any kind of vast holdings. And if I were to die tomorrow, then my wife, I assume, would get the house because she's on the title with me, right? But my son would be left out. My grandchildren would be left out, right? What about my ex-wife?
Okay, well, the ex-wife has no rights to anything.
It just made my day, Don.
Well, the only person in Virginia that you cannot disinherit is your spouse. You can disinherit your children.
And so if you don't include them in the will, or they're not on the title, or they're not on your savings account or your stock account that goes into your asset base, and if you don't have the will, then somebody's making a decision.
Well, you're making an interesting point. You said if somebody doesn't have the will. So in your particular case, you acknowledge that you had a prior wife and you had a child from a prior marriage. Is that correct?
Two. Yes.
Okay.
2 children.
So in your generally speaking, if someone dies without a will, everything goes to their surviving spouse, unless the decedent had children outside of that marriage with that spouse, in which case the surviving spouse would only get 1/3 of the estate, and all of the decedent's children would get 2/3 of the estate.
You lost me there. I'm sorry.
I'm lost.
Okay.
Folks, I don't know. Don't crash if you're driving.
All right, so
clarify that for us real quick.
All right, let's take your case, Mr. Fuqua.
Okay.
All right, you're married. How many children do you have with your current wife?
One.
So you have one child with your current wife, and you have 2 children from your ex-wife.
Yes.
So if you were to die without a will, now we're talking about assets that going through probate. If you own property jointly with your wife, it's going to go to your wife. Forget about that. We're talking about assets that are going.
We're going to talk about how that happened.
Well, we'll talk. Yes, but assets going through probate without a will would go 1/3 to your wife and 2/3 to all 3 of your children.
Okay, without a will.
Without a will.
But if I have a will, because I do have some assets, I have a bunch of cars, they're designated for certain people. But I haven't put that. Now, see, you wrote my will, so you ought to know this stuff.
I don't remember.
Oh, yeah, well, it was 25 years ago, so I don't remember either.
Yeah, and what cars are you talking about now?
Well, let's get it. Yeah, anyway. Okay. Now, my wife is on my title.
Yes.
But if I don't, let's exclude everything else. If I were the only person on title and I die, does that house have to go through probate? And does that thing apply with children and all that stuff?
Well, when you're talking about not having a will, first of all.
Yes.
Okay. So it's generally speaking a house or real estate in an intestate estate, meaning there's no will, drops through the probate estate directly to the beneficiaries. The reason that is because an administrator of an intestate estate has no power to sell that real estate. Okay. So it drops immediately to the designated heirs at law, whoever they may be. In your case, your current wife and your 3 children would inherit title. Now, when an administrator of an intestate estate has to pay bills of that estate and the other assets, the non-real estate assets are insufficient to pay those bills, the administrator may request court permission to bring the real estate into the probate estate to sell that real estate to first satisfy the debts and claims of that estate.
Okay. Anybody else out there, if you got any questions, now's the time to ask, because you can't do it from the casket. Believe me, you got to take care of this stuff before they lay you out. is it time for us to take a break? Because I'm kind of confused by all this intestate stuff.
Yeah, we can take a break.
Okay, let's take a break. Joyce, do the thing when we go to a break.
Yeah. Thank you. Again, this is Joyce Carcase and Paul Fuquay with the Real Estate PB&J Hour, 100.9 FM, 1310 AM, and MoneyTalk1310.com. We'll see you soon.
Money Talk Traffic.
A slow ride if you're heading from the south side to the peninsula. Westbound 64 is jammed up. Little Creek to the HRBT. 264 westbound backing up from the downtown tunnel to Ballantyne. Earlier wreck at Campostella's gone. 64 eastbound in Chesapeake, stop and go from before Battlefield to the high-rise. And moving it across 58 westbound in Suffolk from the Executive Airport to Wilroy Road, where we had an earlier wreck. Tony Hayes, Money Talk 1310 and 100.9.
DIY has never been bigger, and Gary Sullivan is radio's do-it-yourself man on Money Talk 1310.
Hi, I'm Gary Sullivan, host of At Home with Gary Sullivan. For over 30 years, I've hosted America's #1 home improvement show, and we take your calls both Saturday and Sunday from 9 till noon. We'll provide answers on how to do it, the products to use, and where to find it.
At Home with Gary Sullivan. Listen Saturdays and Sundays from 9 a.m. till noon on Money Talk 1310 and 100.9.
Hi, I'm Dr. Miller, a dentist and a volunteer for Dental Lifeline Network. I learned about DLN shortly after graduating dental school. I wanted to help people who are not able to access the oral health care they need. As a new dentist, I wondered, do I have the skills to provide the care they need? And do I have the time when trying to build a new practice? Even now, after 10 years, I can tell other dentists, yes, you can, and this is a no-brainer. Dental Lifeline Network is a nonprofit that has helped me literally change the lives of people in my community through the Donated Dental Services program. DLN asks dentists to volunteer to see just one of the many patients in need each year. If you're a dentist or know a dentist, please share this important information. It's easy. DLN screens those in need and coordinates the initial appointment. Patients are treated right in your office on your schedule. If you're like me and want to make a real difference in someone's life, DLN makes it possible.
Go to willyouseeone.org to learn more. That's willyouseeone.org.
For more than 75 years, the VA Home Loan Benefit has helped millions of eligible veterans and service members achieve their piece of the American dream, a home for their families. Did you know that you could purchase a home or refinance your current home loan with your VA Home Loan Benefit? VA home loans have lower closing costs and generally enjoy lower interest rates than other borrowers. The VA Home Loan may save you thousands of dollars on your mortgage. For more information, visit www.va.gov or talk to a lender of your choice. Choose VA.
Well, we've had a lot thrown at us lately, but hard times just make us stronger. Seen through with faith and family, the bedrock of our community. We do things our own way, and we do what's best. So I've made a choice, and my hope is that you would make one too. For our kids, for our community, for each other. Please, consider vaccination.
Brought to you by the GreenShootsFoundation.org.
Welcome back to the Real Estate PB&J Hour on Money Talk 1310 and 100.9. Rose and Womble Realtors, Paul Fuquay and Joyce Carcase continue their discussion of the fundamentals of home buying and selling.
If you are just joining us, we are discussing wills and trusts with Dominic Lascara of Lascara Law. If you have any questions, please do call in, 757-497-1310.
For those of you who are just new to us, we've just discussed the whole process of probate and the steps that have to be taken to assure yourself that your assets are distributed in accordance with not only your wishes, if at all possible, but also in accordance with law. And that's what Mr. Lascara is so well acquainted with in terms of taking care of the wishes of the decedents. I love that word. They're dead. It's a nice multiple syllable word for dead people. Is that right, Donnie?
That is true.
Okay. So realize this. Once you're dead, you don't have to worry about this stuff anymore. You can sit up there on the next to the golden throne and be laughing about the mess you've left. Like, I know that's going to be my case, unless I listen to him. Now, we've talked about probate. We've talked about intestate, not having a will. We've talked about probate as it applies to a will and probate without a will, right? What is the advantage to somebody who is not of significant means to have a trust? And what is a trust?
Okay. Well, first of all, understand that the word trust could also be a trust created in a will, which would make it a testamentary trust, which would still be part of probate, or you could have a living trust.
You have to complicate. Just answer the question. What's a trust?
Well, the best analogy I like to do, it's a vehicle where you can dispose of your assets after your death without having to go through probate. That may be a simple way to say it, but it's a vehicle where you appoint a trustee, which could be also the person creating the trust, who is in control of your assets and disposing those assets in accordance with the terms of that trust.
So you have both the will and the trust, and you can avoid probate.
Well, you can avoid probate by creating a revocable living trust, putting the assets in the trust. The analogy that I always like to make is, a trust is like a salad bowl, and there can be really nice looking bowls. Some of them are fancier than others. Some of them are, more complicated, but it's important that you put the stuff in the bowl. If you just to have the trust in and of itself doesn't avoid probate, you have to have the assets into the trust to avoid probate. Many times people do trust and they don't fund the trust. They don't put their assets in the trust, and they'll do what is called a pour over will, where they take assets that are passing through the estate and pour it over into the trust. However, that process of pouring over into the trust has to go through probate, which kind of defeats the purpose of doing the trust, which is to avoid probate.
Now, I've been in this business for 25 years, and for that I was an investor, and I owned a fairly large company and was very happy to have all this stuff set up for me. But I always figured that the trusts were for those who have significant asset bases and significant income. And my understanding, that's not true.
Not at all. In fact, I had a client today who her only significant asset is one piece of real estate. The problem is that if she leaves it through her will directly to her children, she's concerned the children who do not get along would not properly handle the disposition of the real estate. So what I told her is I felt the best thing to do was to put the property into a trust, appoint the person that she thinks could handle the distribution of that trust, and as long as she trusts that person, they could sell the property and then distribute the proceeds to her children without them fighting against each other.
Okay, so now you also mentioned a revocable living trust. So let's say I own XYZ and I want to put it in a revocable living trust. That means that I don't have control. I have control over it because I can revoke the trust and I can dissolve it at any time.
Generally, that is very true, and typically the person who creates the trust or the trustor or the grantor, it's usually with these type of trusts, it's strictly for the benefit of that grantor while that grantor is alive, even if the grantor is not the trustee of the trust.
So that person, okay, let's I'm going to go back. I set up a trust for the properties that I own. And they're not consequential by any stretch of the imagination, but there's enough there that I would be concerned about the disbursement of any monies generated from their sale. My question is, do I make that trust revocable and I'm the only person that can revoke it, or do I include my wife? Or I guess I needed to sit down at a long conference table with a whole series of spreadsheets to figure this out. Is that right?
Yes, that's exactly right. Many times husband and wife will create a trust and they want it to become irrevocable once the first spouse dies, so that the second spouse, the last to die, doesn't change the terms that they've agreed on while they were married. So does that answer your question?
I think so. Is it expensive to set up a trust like this?
Not at all. In fact, the trusts are not typically much more expensive than doing wills. But understand this, when the trust is set up and the real estate is is titled into the name of the trust owns the real estate. No longer do you, the individual, own the real estate. The trust dictates what happens to that real estate. It could be sold while you're alive. It could be sold after your death. By the terms of the trust that you want, that will exhaust the asset. So if the trust says, okay, while I'm alive, I enjoyed the benefits of this real estate, everything is for me, but at my death, I want this real estate sold, and I want the proceeds to go to these people. All of that occurs outside of probate. There's no court supervision. The trustee is given the authorities to sell the real estate, and that's what happens. If real estate is sold, just like you would sell the house yourself.
I guess my question now, if you are the attorney who is drafting the trust documents, are you then, in more instances than not, become the executor or administrator of the trust, or do you avoid that scrupulously?
I don't avoid it scrupulously. I've been asked to serve as trustee, and I have at times, but most of the time I want the parties to be who the same parties would be if they were going to appoint an executor to their will. If they typically a family member, a child that's got some ability to handle the responsibilities that come with it. And a lot of times if they don't, it could be a bank. It depends on the asset. It depends on the situation. But I don't push myself to be the trustee or the executor, except in very rare circumstances.
Donnie, I have a question for you. Unmarried homeowners, how do they handle the situation? Do they have equal rights? Whenever they purchase the house, somebody passes away?
Okay, so what you're saying is you've got a piece of property that's owned by more than one person.
Yes.
Who's not married.
Correct.
Well, then it depends. If the property between the co-owners is held jointly with the right of survivorship, then the title to the deed takes care of itself. If one of those co-owners die, it passes to the surviving co-owner or co-owners.
Is that what we mean when we say tenants by the entirety?
No. Okay. Tenants by the entirety is unique only to married people. What's unique about it is not only the right of survivorship to the surviving spouse, but as tenants by the entirety, it's treated as a marital piece of property. So if the husband or the wife on their own got a judgment against them, let's pick on you, Paul. You get out, you got partied one night, and you get in an accident. It's your fault. Somebody gets hurt. They get a recovery against you that exceeds your liability coverage on your insurance policy, and now someone has a $100,000 judgment against you. They cannot take that judgment and docket it against the marital property. The marital property is protected from the acts of the spouse in the singular, if that makes sense.
It does make sense. So that's the specific term, tenants by the entirety.
Tenants by the entirety with the right of survivorship as at common law is what you'll see. Now, back to the next question with joint tenants with the right of survivorship because they're unmarried. Now, what was the question with respect to that?
Joyce asked it.
Yeah, I was just, what would the situation be? I think you actually already answered it for us.
So it would be right of survivorship.
Correct,
now,
right.
If you have a situation where the co-owners do not have the right of survivorship, where they own it as tenants in common, then if that co-owner dies, his interest in the property, whatever it could be a half, it could be a quarter, depends on what the deed says, but his interest in the property will pass through his estate.
Okay, one of the issues that always comes up in closings, or rather during the process of buying a house, is the title in one name and two names on the loan documents, or the reverse. Yeah. Does that have a significant impact, and should they match up?
Really, it doesn't. It doesn't have an impact, and I think a lot of times what we're talking about is maybe a veteran whose wife is not included, and what happens is they take it as husband and wife tenants by the entirety, but say just the husband or just the spouse, the wife rather, is on the loan itself. No difference. If the husband who has the loan in his name dies, the property goes to the spouse. She doesn't have to pay off the mortgage. She can continue to make the mortgage payments.
That brings up something, and I know this has become an issue throughout our industry, and that is the reverse mortgage, where as an indebtedness has been incurred on a house that was previously paid for, and that money has been paid out either in a lump sum or over a period of years. I know that it's a roll of the dice. I know of one gentleman who did a reverse mortgage very early on, and he outlived the actuarial tables. So he was collecting monthly a significant amount of money because he outlasted the tables by almost 20 years. So the insurance or somebody took a hit. How do you deal with that kind of situation if I were to go with my wife and put a reverse on a house?
In what effect, though? What do you mean, how would I deal with it?
I mean, is there, number one, would you advise doing that at reverse mortgage generally?
Well, reverse mortgages work for some people.
Jeez. PB&J, some people like.
Well, if you can't afford your mortgage payment, for one, and you want a place to live the rest of your life where you no longer have to make a mortgage payment, a reverse mortgage can be ideal.
Okay. You had more to add. Please go ahead.
Well, then you have to know what happens when I die, and
yes,
and that all depends. Because if the payoff on the reverse mortgage, you remember that a reverse mortgage, you're not paying anything, so it's like a negative amortization. The interest that you should have paid is being added to the balance that you've already borrowed. And typically, except maybe in this current market, typically the balance on the mortgage starts to increase more than the equity growth on the real estate. So it gets to a point where the balance on the mortgage could be far greater than the value of the house. Fortunately, if you're the decedent, if you're the recipient of the real estate, or it comes to the estate and you owe this money, there's no personal liability on the estate or the executor or the family members. They can simply walk away from the real estate.
Okay. All right. That helps clarify. So it removes some of the concern that I've heard expressed by people about reverse mortgages.
Well, one of the other concerns is that I've seen a lot more aggression with reverse mortgages in the sense that I've always understood, and I may be a little bit off, but it's an FHA program that always allowed the estate 6 months in which to sell the real estate if they want to keep it. I've seen some people tell me, I haven't dealt with it firsthand as a lawyer, that they've been threatened with 3 months. I haven't seen that personally, but the general rule that I've always understood is that FHA allows 6 months for the estate to sell that real estate, and then on occasion they can grant several 3-month extensions.
Okay. We're going to take another short break. This is the Real Estate PB&J Hour with Paul Fuqua and Joyce Carcase. MoneyTalk1310.com, 1310 AM, and 100.9 FM. We have a lot more to discuss.
Question: what will you find on all over-the-counter or OTC medicine packages to help you choose the right drug and use it safely? The answer: the drug facts label. This label lists the medicine's active ingredients and purpose, how much to take, and warnings you should know before using it. Remember, even OTC medicines you buy without a prescription can cause side effects you don't want. So follow the information listed on the drug facts label. For more information, visit fda.gov/drug facts label. A message from the U.S. Food and Drug Administration.
Most of us like to be out in the sun. That's why sunscreen and other safety measures are key to protecting your skin from aging and cancer. The FDA recommends using a sunscreen with a sun protection factor, or SPF, of 15 or higher. Also, look for broad spectrum on the label. That means both harmful ultraviolet A and B rays are blocked. UVA rays age the skin, UVB rays burn, and both cause cancer. But the perfect sunscreen doesn't count if you use it wrong. Don't need sunscreen on a cloudy day? Wrong. 80% of UV rays still get through the haze. Only use sunscreen at the beach? Nope. Anytime you're outside, UV rays attack the skin, so you need protection. And you have to reapply sunscreen every 2 hours. Remember, SPF plus broad spectrum equal healthy fun in the sun. Visit www.fda.gov/sunscreen for more information. A message from the U.S. Food and Drug Administration.
If you suffer from COPD symptoms like shortness of breath and fatigue, where do you turn? There are medications and oxygen, but do you know about pulmonary rehab? 3 out of 5 COPD patients have never heard of it. Pulmonary Rehab is an exercise, education, and support program that gives you tools to manage your condition, and Medicare typically pays for it. So whether it's grocery shopping on your own or just walking across the room, Pulmonary Rehab can help you. Visit livebetter.org to find out about your options for pulmonary rehab today.
Welcome back to the Real Estate PB&J Hour on Money Talk 1310 and 100.9. Rose and Womble Realtors, Paul Fuquay and Joyce Carcase continue their discussion of the fundamentals of home buying and selling.
Welcome back. This is Joyce Carcase with Paul Fuquay. We hope you enjoy the broadcast and learning a little more about the market and your rights as a buyer and seller. If you have any questions or are interested in hearing a topic we have not covered, please let us know. You can call us again at 757-497-1310 or reach out to us at Fuquay Home Sales, and that's Fuqua Home Sales, or Carcase Home Sales, Carcaise. You can also listen to past episodes and subscribe to our YouTube channel, The Real Estate PB&J Hour. Now we're back with Donnie Lascara.
Our role as real estate agents is to avoid, to the best degree possible, realtor speak. And we like to deal with people who are involved in the industry who also can speak regular English without throwing out all the Latin phrases and those elements that tend to be seclusionary in protecting a profession. And that's one of the reasons I like Donnie Lascara. Now, you asked me to ask you a question, but I'm going to ask you to ask yourself the question, and then you can answer it. That's a good way to be an expert.
Okay, well, we started talking about probate in the process, and under Virginia law, it's not the end all. If you go through probate in Virginia, it's not a terrible thing. If we were in the state of Florida, we wouldn't be having this conversation. But probate is not devastating to anyone. It's just a process that you have to go through. How do you avoid probate with the to get real estate out of the decedent's name? We talked about a trust, how a trust can be disposed of. But there's another tool that was adopted by Virginia back in 2013 called the Revocable Transfer on Death Deed Act. And I use that quite often. I'll have my clients who want to see their property go to specific beneficiaries convey their real estate while they are alive to the beneficiaries under this revocable transfer on death deed. What happens is that deed does get recorded. It lies dormant in the records, the land records of the clerk's office where that property is located. But it has no force and effect until that person dies. And prior to that person dying, they can change their mind. It's revocable. They can sell the property. They can still encumber the property. They can borrow money against it. They can change their beneficiaries. Nothing is in stone. But if that deed gets put to record and they do die, then that property gets transferred to those named beneficiaries on that deed outside of probate.
Okay, folks, you got that? That's a quick encapsulation. I've been keeping notes, and I'm certain Joyce and I will prepare a brochure on this, and we'll definitely provide Donnie Lascara's address and phone number and email and all the other stuff. But go ahead and tell people how to get a hold of you so that they can call me and they can call Joyce, and then we can give the number. That way we've got the lead. But you go ahead and do it.
Okay, well, first of all, I like to say that I'm conveniently located at 652 Independence Parkway in Chesapeake, right behind the Lowe's. Very easy to get to, right off of Battlefield Boulevard in Volvo Parkway. My phone number at the office is 757-410-8355. And my email address is D for Dominic, Lascara, and that's L-A-S, as in Sam, C-A-R-A, at lascaralaw.com.